That's 1 minute past 1 today, and hopefully you're all managing to join in with the Compass Review webinar for the end of the legal year. And first of all, I'd like to say thank you to Amber, because it was Amber's idea that we should have a webinar that reviewed all of the developments which might be relevant to our area of practice over the last year, given that we've all been missing out on the main source of legal updates, not only CPD, but the all-important coffee after court, where we can all sit down and swap ideas and shamelessly copy successful arguments that our colleagues have been making. And this year, of course, despite the disruption to the hearings in court and the normal run of court business, advocates from Compass have been busily appearing both in person at proofs and fatal accident inquiries when those resumed, and also at virtual hearings throughout the whole period since March. And we'll have a particular update on the conduct of a fatal accident inquiry from Gavin Anderson shortly. But first, I'd like to kick off today's proceedings with a talk from Kate Bennett. Hi, Kate. Kate
Hi.
Is going to be explaining the decision of the Supreme Court in the case of Swift and Carpenter to us in relation to the correct approach to the calculation of accommodation claims in the negative discount rate era. So I'll hand over to you now, Kate.
Thank you. Good afternoon, everybody. I'm sure you're all aware of the decision in Swift against Carpenter, and you may already know what I'm about to discuss with you. But given that we are reviewing the legal year and this was a significant and important decision for personal injury practitioners, I thought it'd be a worthwhile topic to discuss. The decision was issued on the 9th of October, and it resolves almost the approach to calculating accommodation claims. Excuse me. Swift challenged the previous approach set out in Roberts against Johnston, challenged whether it was correct, and it clarified the correct approach to calculating claims henceforth. Before considering the particulars of Swift, it might be helpful to have a historical recap in relation to the problem with accommodation claims and the solution that was provided almost 3 decades ago by the Court of Appeal in Roberts against Johnston. So the problem is that when a pursuer needs to purchase a more expensive property as a result of an injury and the needs from that injury, the question arises as to how to measure that loss. The property market historically and typically to date has shown growth. Therefore, the capital asset that the more expensive property is predicted to rise in value, and usually over the rate of inflation. If a pursuer was awarded the cost of the accommodation in full, that is an asset which retains and will increase in value and will result in a windfall to the pursuer's estate upon his or her death. So in Roberts, the underlying rationale for their approach was based on the principle that it was wrong to award the full capital cost of the accommodation because that would result in overcompensation or a windfall. And the problem was how to measure that loss and avoid the claimant or his estate achieving a betterment or overcompensation. The solution or the guidance provided in Roberts was based on the premise that they would compensate the pursuer by valuing the notional cost of temporarily giving up the use of money required to fund the purchase. So the idea being that the pursuer would pay for the additional cost of the accommodation out of the other heads of claim. So they weren't awarding the cost of accommodation itself. And the solution, the formula was to link the loss to the discount rate. So the formula derived was to multiply the increased capital cost required to buy the alternative accommodation by the percentage discount rate applicable and apply the life multiplier. It's exciting stuff. But this approach had inherent problems because it assumes that a pursuer would be able to fund the capital acquisition out of the sums awarded. And it was particularly unsatisfactory for pursuers with immediate and pressing needs, but a relatively short life expectancy. And although the approach was criticised over the years in a number of authorities, the courts were never invited to revisit it. And at the time the decision in Roberts was handed down, the discount rate was 2%, and for the majority of time thereafter, 2.5%. However, as we all know, in March 2017, a negative discount rate was introduced. And by the law of unintended consequences, this resulted in findings that there was no loss for a pursuer who required to buy a more expensive property to meet their reasonable needs, because applying the formula in Roberts to the negative discount rate results in an overall negative award. And this transpired in the case of JR against Sheffield Teaching Hospitals NHS Foundation Trust in 2017. In a judgment by Justice William Davis, it was recognised that applying Roberts unjustly led to a nil award, but the court was not prepared to revisit matters. That case was appealed, but it settled before the appeal was heard. Now, the same issue arose in Swift. So in Swift, Miss Swift sustained serious leg injuries in a road traffic accident, which ultimately led to a below knee amputation of the left leg and serious injury to the right foot. At trial in 2018, she was awarded more than 4 million in damages on the basis of a normal life expectancy. It was agreed by parties that Miss Swift required a new house given her injuries, and it was reasonable that she move. Justice Lambert assessed the capital cost of the required special accommodation, as it's called in England, was £900,000 more than the appellant's current home. But she concluded she was bound by the decision in Roberts and therefore awarded no damages for accommodation. The appellant appealed to the Court of Appeal, who, in addition to hearing from both parties, received submissions from the Personal Injuries Bar Association as interveners. The appellant argued that the court had the power to revisit Roberts against Johnston and that it should do so because it was no longer fit for purpose in light of the new discount rate. The respondent argued that the court was bound by Roberts. It had been treated as precedent for decades. It was agreed that the questions for the court to decide were, is the court bound by Roberts against Johnston? And this question was subdivided into 3 questions. Does it apply? If yes, is the court prevented from revisiting it? And if no, should the court revisit it? Excuse me, I've lost my notes. And the second question for the court was, if the court was permitted to re-examine Roberts against Johnston, what approach should be taken? Should the court award the full capital value, or should the court award the full capital value less a sum to reflect the windfall, or reversionary interest as it's called? And if the latter, how should the value of the windfall be calculated? Lord Justice Irwin handed down the Court of Appeal's unanimous decision. In relation to the first question, the court held that Roberts against Johnston did not establish a legal principle. Instead, it provided authoritative guidance given the specific conditions prevailing at the time. The reasoning in Roberts was a means to an end, fair compensation, but not overcompensation. However, that guidance was now ineffective in achieving the object for that object, it couldn't be regarded as fair or reasonable compensation to award no damages in respect of a large established need, simply on the basis that if all relevant predictions hold good, there would be a windfall to the claimant's estate. The formula in Roberts therefore needed to be revisited. Turning to the second question then, what approach should be taken? Well, the court heard expert evidence from economists, actuaries, mortgage experts, experts in the valuation of reversionary interests in property. The parties agreed a number of paradigm cases, and they're set out in the annex to the judgment. I've just been told I've got 2 minutes left. I'll try and whiz through this. So the court held that the lump sum full capital value of the £900,000 would provide a windfall to the claimant, so should be avoided if possible. But the court said if it was possible to calculate the windfall or his notional reversionary interest and deduct it from the full capital value, then that's the method that should be adopted. So how to value the windfall or the reversionary interest? Well, the existing market in reversionary interests is very small, 1 to 2 sales per year apparently. But despite this, Lord Justice Irwin said that the market approach must in principle be the correct way to value a reversionary interest. But he took a cautious approach in relation to the rate suggested by the evidence of the expected return in the market, and adopted the lowest return on investment seen in practice by the only expert with experience in the field, and that rate was 5%. So in conclusion, damages awarded must be calculated by awarding the additional capital cost of the new property less the present market value of the reversionary interest in that property. And the present market value of the reversionary interest is calculated by using an annual rate of return, 5%, over the claimant's life expectancy. Now, the method for calculating that is well, I found it almost impenetrable to ascertain from the judgment. But Mr. Milligan managed to source the formula, and it should be posted on the webinar page so you have access to it. Final observations. What does this mean in practical terms? Well, it's a new method of calculation and it's to be welcomed, but it's not necessarily brought a universal approach. While the Court of Appeal held that for longer lives lived during conditions of negative or low positive discount rates, the guidance should be regarded as enduring, it acknowledged that there may be cases where the guidance is inappropriate. However, it didn't consider the circumstances in which the decision might not apply. So caution should be taken as, in relation to cases that don't fit the model in SWIFT, and that might be cases involving pursuers with short life expectancies. Equally, should the discount rate move above a low positive, whatever that might be, it may be questioned whether the new guidance is applicable. Apologies if I've overrun, but thank you for listening to me.
Thank you, Kate. That was extremely helpful. And just to confirm that the formula, which hopefully will be the answer to all of our prayers, will be posted on the Compass webinar page later. Now, I've been asked to remind everybody that although we're not taking questions during the presentations, that there is a 15-minute slot at the end of today's seminar to ask any questions you have. And the way to do that is to go to the bottom of the screen and to send questions using the chat function on Zoom. And I'll go through those at the end and call on the appropriate speaker. So moving on then speedily to our next speaker, who is Gavin Anderson, who's going to give us an insight in relation to how a virtual FEI is held in these present times. Gavin.
Thanks very much, Astrid. I thought it would be useful in reviewing the legal year to look at how matters have developed from practicing in the FEI sphere in real court to virtual court. And looking back to 2019, we were all preparing cases on the basis that we were going to be in live in-person hearings throughout 2020. And many of us had never heard of WebEx at this time last year, but we've come to be quite familiar with it. I thought I would mention two inquiries in particular, and I should say a number of counsel from Compass Chambers appeared in both of the inquiries I'm going to mention, but any views I express are, of course, only my own. The two I thought I would mention, firstly, the Sombra FAI. For those interested, that's 2020 FAI 34 on Scott Court's website. That concerned a helicopter crash in August 2013, where a number of passengers died as a helicopter approached Sombra Airport in Shetland. In 2019, the Crown advised that they were going to hold a fatal accident inquiry, and preparations for that began. The other inquiry I wanted to mention is the Parkinson Fatal Accident Inquiry, 2020 FAI 32. That inquiry concerned the death of a school child in March 2014 in Dundee. She had been under the care of the local health board, and the inquiry was into the quality and standard of care provided to her. Both of those inquiries commenced as real in-person inquiries, and a number of preliminary hearings were held in actual court. You will have noticed that both of these inquiries took place a number of years after the deaths concerned. So in Sombra, for example, we had preliminary hearings in Aberdeen Sheriff Court in January 2020 and in Edinburgh in March 2020. And that was with a view to an in-person inquiry at the new Inverness Justice Centre in May of this year. And Sombra involved 10 separate participants. In Parkinson, we had 6 preliminary hearings in live court at Dundee Sheriff Court. Such was the complexity of the medical evidence to be considered. There were 4 participants in that inquiry. So in both of those inquiries, everyone prepared on the basis that there was going to be an in-person inquiry, with witnesses giving evidence in live court using paper documents, or at least scanned in for use, but in a courtroom setting. As lockdown approached, it became clear that neither inquiry could take place as planned, and after a delay, both moved onto the WebEx platform, both for further preliminary hearings and for the inquiries themselves. So what were the initial challenges? Well, the first and perhaps most difficult was how to marshal documentary evidence. Documents which we thought we would be using in paper form had to be made available electronically in an agreed bundle, carefully numbered so that everyone could access the electronic bundles online. We had to consider how witnesses were to be allowed access to documents prior to the inquiry, such as reviewing their witness statements before giving evidence. In some cases, statements were posted out, securely of course, so witnesses could read them. In other cases, and Sombra as an example, documentation was emailed all over the world, including as far as Australia, in order that witnesses could prepare for the inquiry. Also, how were witnesses to access documents during the hearing itself? Were they to have copies of the documents in front of them from where they were giving evidence, or simply to see them on the screen? In addition to marshalling documents, how do we marshal the witnesses? Where were they to give evidence from? Did they have sufficient internet bandwidth to run the platform? What was the background in front of which they would be appearing? Was it appropriate for court use? And how were they to be scheduled in accordance with the WebEx platform? We then had to consider, well, what arrangements would be made for solicitors and counsel using the new platform? Would they appear from home or from their offices? Or for counsel, perhaps from 142 High Street? Should solicitors and counsel be in the same room albeit socially distanced, during the inquiry. Where they were, that seemed to work better because discussions could take place more easily. Should solicitors and counsel have multiple screens in front of them so that they could watch the evidence on one screen and access documents on the other? How were we to deal with screen breaks? Because, of course, the Health and Safety Executive provides guidance on screen breaks. Were we to have regard to that in planning the court day? If people were working remotely, such as solicitors and counsel, and not in the same room, how were they to communicate during the inquiry? By email, by text, or a WhatsApp group involving the participants concerned? All these things had to be considered and considered quickly. So what were the positives from the WebEx platform? Well, I suppose the first and most obvious is that these inquiries took place at all. They were both inquiries taking place a number of years after the events involved. I think that was important for the families of the deceased, that they didn't have to wait any longer than was necessary. Another positive was that solicitors, counsel, and the Scottish Courts and Tribunal Service, together with the sheriffs, worked collaboratively. There was a very positive can-do attitude to getting these inquiries and others up and running. There was some, I suggest, increased informality, especially as between bench and bar, including some of the informal discussions that take place in the practice sessions before WebEx goes live. And overall, I think that was a good thing. Another positive was that professional witnesses were perhaps less inconvenienced. So in Sombra, for example, air accident investigators who are based in Farnborough did not need to travel to Inverness to give evidence in person. One may contrast that with the Clutha inquiry at Glasgow, where they did require to travel to Glasgow to give evidence in person. In Sombra, we took expert evidence over WebEx from experts in Australia. In Parkinson, there was hot tubbing of the 3 expert medical witnesses, each of whom appeared simultaneously on the WebEx platform and were questioned one after the other on the various topics raised. And again, that seemed to work well. 2 of the experts were in Scotland and 1 was in England. As to the negatives of the procedure, well, perhaps one might ask, did the participants truly feel involved in the process, particularly the families of the deceased? Did they have their day in court? How were vulnerable family members to access the internet platform? I would also query whether the inquiries were truly public in nature. An FAI is meant to be a public examination of the facts, but there was a notable increase in the use of written evidence, notices to admit information, minutes of agreement, or the giving of evidence entirely by prior statement. All of those procedures have their place, but to the public who may be interested in the public nature of inquiries, they perhaps found some of the evidence difficult to follow. Unlike inquiries under the 2005 Act, there is no routine procedure for FAIs to publish witness statements online as the inquiry proceeds. One may also query whether the WebEx platform is really most suited to those inquiries where there's not much in dispute. I think in more contentious hearings, an in-person hearing may be better in an exercise at getting to the truth. Inquiries of this nature also take longer to resolve minor issues. Astrid mentioned having coffee or not having coffee at the moment with one's colleagues. Similarly, not being in court can make it difficult just to resolve issues. Instead of the quick 5-minute conversation about what might be in a joint minute, there's an endless round of Zoom calls, emails to resolve issues, which can be resolved in live court more quickly. Finally, there needs to be much more preparation for these hearings, as I say, in terms of documentation and communication. As we go forward, practice in this area will vary. At the moment, I know that, for example, in Edinburgh, there is a live in-person fatal accident inquiry part heard. In Grampian, Highland and Islands, all FAIs are to be by the WebEx platform for the foreseeable future, including one which is due to start next week. I'm also aware of a significant inquiry scheduled for Oban Sheriff Court in February of next year, again entirely over the WebEx platform. I think going forward, in the short term, WebEx will continue because it really is the only way to get a lot of people together. But as time passes, hopefully a vaccine becomes available and there's some return to normality, we can hope that WebEx becomes not the only way to conduct these inquiries. It may still have its place. We may move to a hybrid system, but I, for one, will be very glad to return to the traditional model of inquiries in person. Thank you very much.
Thank you very much indeed, Gavin. That was very interesting, particularly your point about the suitability of WebEx for more contentious matters, because from the civil court's perspective, there has been quite a lot of discussion as to whether quite lengthy clinical negligence proofs can go ahead virtually, for example, and particularly when things are contentious in relation to factual evidence, it's quite hard to see how that is going to fit easily into the WebEx model, isn't it? Thank you very much. And we now have Amber Galbraith, QC, who's going to discuss for us the case of Andrew Wright against the National Galleries of Scotland.
Hello, good afternoon on this miserable afternoon. Thank you, Astrid. So I would like to discuss this case, which I was involved in at first instance, and then went to the Sheriff Appeal Court earlier this year. It was heard in February, so it was in person, and the court made some interesting observations about occupiers' liability. The case again called before the Sheriff Appeal Court, this time via WebEx in August, because a pursuer's offer had been lodged and the defenders sought to argue that the mechanism could not apply on appeal. So in terms of the facts of the case, this was an accident that happened back in November 2016. Mr. Wright was a delivery driver. He was employed by Graham's Family Dairy, and so he delivered dairy products. And part of that involved him delivering to the Scottish National Portrait Gallery in Queen Street. I'm sure many of you have been and will know the layout, but if you go in the main public entrance from Queen Street, there's a cafe on your left. And behind the cafe, there's a kitchen, and there's a corridor attached to that kitchen where the fridges are located. Beside the fridge corridor, there's the back door. And the back door leads into an alleyway behind the gallery. So as you would expect, milk deliveries are made very early in the morning, before 7 and usually in the wee small hours. And up until the November 2016, the system for delivery was that Mr. Wright would go to the back door of the gallery, buzz the security guards, and they would come and let him in, and often they would help him in, hold the door open and help him put the milk and things in the fridge. This system meant that Mr. Wright never had to go into the kitchen or any other part of the building. He just popped his things in the fridge and left by the back door. The defenders, who were the gallery, carried out a security review in 2016 and changed their policy for allowing access out of hours. And they required delivery personnel to use the front door before 7 a.m. And that was the extent of their direction. So for Mr. Wright, that meant he couldn't go to the back door anymore and put his milk straight into the fridge. He had to go to the front door. But the trouble is, they didn't tell him what else to do. So he had to work it out for himself as to where he was to go. So on the 19th of November, he arrives at the front door with a wheeled caged milk. I'm sure we've all seen them in Tesco's and things. This cage was about half full of milk. The security staff let him in, And then he was left to his own devices to walk to the fridge area. So he walked through the cafe, through the kitchen, but unbeknownst to Mr. Wright, because he'd never been there before, is that there was a step between the kitchen and the fridge corridor. So the cage toppled over this step, taking Mr. Wright with it. After the accident, the gallery changed the procedure and they provided that deliveries could be made by an alternative route, which avoided the need to go through the kitchen and go down this step. Mr. Wright suffered soft tissue injuries and quantum was agreed at £2,500, living the dream. So it was only liability that was in issue at the proof. The case was raised only against the gallery as occupier under common law and also under the workplace regs, in particular Regulation 17. The argument being by changing the procedure for deliveries, they had created a potential danger, having to walk through an unlit kitchen with a step. And the argument was that they, having done that, they required to address their minds as to how that could be done safely. There was no case directed against the pursuer's employers or the operators of the cafe, and that significantly exercised the sheriff during the proof. The cafe was closed at the time of the delivery. There were no members of staff there. And the point had to be made repeatedly to the sheriff that to direct his attention to the case before him and not be concerned about other cases that could potentially be made. And it was repeatedly suggested that it was the operators of the cafe that were the occupiers of the kitchen, not the gallery. And it did take up quite a considerable time at the proof, a discussion as to whether there could be more than one occupier of a premises. However, I think ultimately that the sheriff was satisfied that there could be. The sheriff at first instance decided there was no breach of duty. He thought that the defender's control was limited and didn't extend to the control of the accident. At various stages, the sheriff conflated the issue of control with knowledge of use. He did accept in his decision that if the defenders knew the pursuer had to deliver milk to the fridge, then they might be under a duty to consider how it could be done safely, given their change of procedure. But he was not prepared to accept the defenders knew the pursuer would deliver milk to the fridge. And in particular, he wouldn't accept that the defender's employees, namely the security staff who helped him, because they knew that happened, he did not impute that knowledge to the defenders. So it was appealed by the pursuer, and the point of law was just basically whether there was a duty of care that was breached. The Sheriff Appeal Court said that the term occupier meant the same under common law and under the 1960 Act, as I think we all know. And it was someone who had sufficient control over the premises to place them under a duty of care. The Appeal Court highlighted the defender hadn't admitted being an occupier at any stage, but the Appeal Court was satisfied that there was control, which was obvious, given the control of entry to the premises. And given that the defenders were occupiers, the court turned its mind to the nature and extent of the duty, and that depended on the factual matrix. The Appeal Court found that the sheriff had elevated the issue of concurrent occupation, being the gallery and the cafe owners, and that he had diverted his attention from a proper analysis of what duties were incumbent on the defenders, ignoring what may be incumbent on the cafe. And unlike the Sheriff Appeal Court found that because the security guards were aware the milk was delivered via the back door, this imputed knowledge to the defenders. And in light of that, by changing the arrangements, they were required to consider how to organise pedestrians safely. As indicated, the pursuer relied on Regulation 17 of the workplace regs. there are relatively few cases dealing with Regulation 17. I think it's quite often overlooked, but it is quite a useful section. And the general proposition was accepted by the Sheriff and the Sheriff Appeal Court that the extent of a common law duty is informed by the regulations. And I think this is now a settled position. The Sheriff, though, did not think that the regulations added anything to the common law case. And the Sheriff Appeal Court disagreed with that and found that the Sheriff had misdirected himself. And because the gallery was the pursuer's workplace for this period of time, the regulations imposed a duty on the defenders to consider a suitable and safe access or traffic route within the gallery. So the appeal was successful and decree was pronounced in the pursuer's favour. So far, so good. But that wasn't quite the end of it, because a pursuer's offer had been lodged. With a deduction for contrib, the pursuer was ultimately awarded £1,875 with interest from the 5th of February 2019. A pursuer's offer had been lodged in 2018 for £1,750. So doing all the calculations, there was just by a squeak, the pursuer benefited from was awarded more by the appeal court. The defender argued that the mechanism of pursuer's offer was not open to the pursuer. The first argument was one of fundamental competence. They argued because Chapter 27A was in the ordinary court rules, there was no equivalent power in the Sheriff Appeal Court civil rules, so it was not open to the Sheriff Appeal Court to apply these rules. The Sheriff Appeal Court dismissed that. They said that there was an inherent power to apply the Chapter 27A rule, and although the rule talks about sheriff, they read it as meaning Sheriff Appeal Court because it was the appeal court that pronounced the judgment. The second argument was based on the Inner House decision in Anderson against Imrie. In that case, a pursuer's offer had been lodged during an appeal process, and the Inner House found that the pursuer's offer procedure was not open to a pursuer during an appeal. And the defender in this case argued for that reason that the pursuer's offer had no effect beyond the first instance proceedings. That argument was rejected. The appeal court said this is quite distinct from Anderson, and in fact it was the converse, and that it was perfectly possible. It doesn't matter whether the judgment comes from the Sheriff or the Sheriff Appeal Court. If there's a pursuer's offer in the first instance procedure, then it bites. So both, obviously the decision of the appeal court is available on the Scottish Court website, but they also helpfully put a note about the pursuer's offer findings on the website, so that might be of assistance for you. So I think that concludes my comments on this case. Thank you very much.
Thank you very much, Amber. That was very interesting indeed, covering a lot of ground there in a short time. Before we move on to Robert Milligan, I'd just like to remind everybody that if you do have any questions for the panellists, please use the chat function, and I'll let you have the opportunity to put those questions at the end. So without further ado, Robert Milligan QC is going to talk to us about expenses and bus crashes, which is really quite a tangential title. So I'll be interested to see what Robert's going to say about that.
Good afternoon to the millions listening at home. I hope you are safely and warmly tucked up as the rain batters against the windows and the street lights come on at 20 to 2 in the afternoon. I'm going to talk about two cases today, completely unrelated beyond the fact I was involved in them. And the first is a bit of a collector's item because it was one I was actually successful in. That's what I'm going to concentrate on because that's probably the most interesting legally. And it involves the not unknown scenario of a single vehicle road traffic accident where there's a question about some external cause, usually black ice or oil on the road or something. And the question whether the driver is able to overcome the inference that is generally drawn from the fact that a vehicle has left the road. The case is Woodhouse against Lochs and Glens Transport Limited. I hope you have been provided with a handout. It's not particularly essential if you refer to it or not, but it might just be of some assistance to you. The case involved a coach driving northwards on the A83 at the Rest and Be Thankful on a day not unlike today, wet and windy in March. The findings of the judge, although this is contested, ultimately the findings of the judge were that the coach stopped at a lay-by, then pulled out and accelerated over a distance of 100 metres or so, up to 40 to 45 miles an hour, before being struck by a strong gust of wind from the left-hand side that pushed it across the road, in other words, towards the oncoming lane, that the driver had time to slow, correct her position before being struck very soon afterwards by another equally strong gust of wind from the right that actually pushed the bus off the hard standing. It then continued on the verge for a bit, and because there was quite a steep bank down on the left, wasn't able to get back on the road before gravity took over, and it rolled down the embankment, and indeed rolled right the way, full 360-degree roll before landing back up on its wheels, fortunately just short of Loch Restall. There are actually remarkably few serious injuries, particularly amongst those passengers who had their seatbelts on, so maybe quite a good indicator of the need for that. But a number of passengers were injured, including Mr. Woodhouse, and his case was led essentially as a test case. And the defender's position was firstly that there was no inference of negligence to be drawn where a coach leaves the road under adverse weather conditions, and secondly that here there was an unforeseeable external cause, namely not just the strong wind but the unusual event of it hitting from both sides, one immediately after the other in opposing directions. And on the handout you'll see a picture of the coach, as I say, really remarkably undamaged after the excitement of rolling down the bank. Damages were agreed at a relatively modest level, and the pursuer moved to have the defenders ordained to lead at proof. I was slightly surprised, to be honest, that motion was resisted, but not only was it resisted, it was successfully resisted. And that's the second time I've done 3 proofs similar to this. This is the third one. And in one of the previous ones as well, the defenders successfully, although as it turned out wrongly, opposed the motion to ordain the defenders to lead. And where damages are sorted out and the onus is on the defenders to show, to rebut the inference of negligence, then certainly my view is, and it was the view of the inner house here, that it's really much more sensible for the defenders to lead rather than the pursuer having to anticipate, as it were, the lines of defence, and that this has led the judge into some confusion in his reasoning. As I say, on the face of it, it was a relatively straightforward dispute, and that the defence was that the weather conditions were damnum fatale, that they were not reasonably foreseeable, and that the driver was not negligent in failing to anticipate them. But that essentially the defence was rejected, and the judge held that the weather was pretty bad, but on that stretch of road that the driver was familiar with, there was nothing particularly unforeseeable about the strength of the wind gusts. Notwithstanding that, the Lord Ordinary still went on to say that he didn't think the driver had been negligent. And I think this is where the fact that the pursuer had led rather than the defenders had really confused the judge in his thinking about where the onus lay in that situation. And as you'll see from paragraph 34 of the inner house's opinion, they were not at all impressed with the Lord Ordinary's reasoning. Having addressed the test for an appellate court, they went on to say that with all these matters firmly in mind, the court has concluded that despite the care which is clearly taken in his assessment of the testimony of the Lord Ordinary, he, 1, misapplied the maxim res ipsa locta to the facts, 2, was plainly wrong in holding that the speed of the bus did not make it less easy to handle, 3, failed to consider relevant evidence, 4, has misunderstood the driver's testimony on speed, and 5, reached a conclusion which cannot be explained or justified. So not exactly a ringing endorsement of the Lord Ordinary there. And what they went on to say was that the most problematic flaw is the Lord Ordinary's application of the maxim res ipsa locta. Use of the maxim in the context of road traffic cases is a familiar one, and you look at cases like O'Hara and Mars. And what they said is that when it applies, the defender must demonstrate that the accident occurred without fault on his part. It is not enough to proffer a possible alternative non-negligent explanation. The defender must establish facts from which it is no longer possible to draw the prima facie inference. And they went on to say that the Lord Ordinary correctly determined that the maxim applied. Buses which are driven in a safe and proper manner and at a reasonable speed do not leave carriageways of major trunk roads in winds of the relatively common velocity present at the time of this accident. The defender is thus required to prove on the balance of probabilities the accident had occurred without negligence on the part of their driver. Unfortunately, the Lord Ordinary didn't approach the matter in this way. A different Lord Ordinary had declined to ordain the defenders to lead at the proof. Such an order would perhaps have reflected with greater clarity the correct application of the maxim and the circumstances admitted on record. Be that as it may, the Lord Ordinary, in his approach to the proof, returned the onus to the pursuer to prove what the Lord Ordinary described as his only suggestion of fault, that being, according to the Lord Ordinary, the actions of the driver and in particular the speed at which the bus was being driven. That was not the manner in which the pursuer's case was pled or presented. The pursuer did not need to advance any suggestion of fault. A prima facie inference of negligence existed by virtue of the facts admitted on record. As the pursuer submitted, the Lord Ordinary effectively required the pursuer to prove negligence twice. And that's the key point, is that you don't have to, as a pursuer in that situation, you don't have to show what it was that the driver did wrong. You don't have to show that the driver was going too fast, or that they took their eye off the road, or that they've mispositioned the vehicle, or anything like that. You simply have to establish that the vehicle has left the road, and that then raises the inference of negligence, and it's for the defenders to rebut it. And generally speaking, the case law shows that's a difficult thing to do. It's usually successfully pled when there's some third-party interference, for example, a child running out into the road, or as I've already mentioned, black ice or diesel spills are a bit more difficult, whether they can be viewed or not. I'm just going to very briefly touch on the next case, a very unusual one, AP against NHS Lanarkshire. It was a clinical negligence case in the Sheriff Court. And what happened was that the proof was discharged due to lack of court time, which I'm sure you're all aware is a pretty common event in the Sheriff Court. The pursuer had some uncontentious productions to lodge, tried to do so by motion. The sheriff clerks insisted that the proper course was to enrol a motion to vary the timetable. So the pursuer did that with a detailed explanation of why they wanted to vary the timetable so they could lodge these specific productions. The defenders didn't oppose the motion. The pursuer lodged their reports, and then, to their surprise, got met by the defenders lodging a whole load of reports of their own, which ultimately were sufficient to persuade the pursuer that the case was no longer worth proceeding with, so they had to abandon. There was then a fight about the expenses on the basis that if those productions had been lodged when they should have been, then there wouldn't have been all the expense of the proof, etc., in the first place. And ultimately, Sheriff Holligan took the approach that the defenders were entitled to their expenses, but they should be modified or restricted to 75%, essentially as a kind of slap on the wrists for that kind of behaviour. And I think the key point from that, because I have seen this happen before in other cases, although not so extremely, is that if you want to lodge late productions, whether you're pursuing or defending, it is very important when you enrol to vary the timetable that you only do so in relation to your own productions. It's very easy just to say to vary the timetable to allow the data productions, but it's important to restrict it to your own. Otherwise, you're really just opening the door to the other side to lodge whatever they want to. Okay, so I think that's probably my time up now, and so I think I'll pass back to Astrid. Thank you very much.
Thanks very much indeed, Robert. That's a fascinating tactical insight there. I think it is interesting that even in cases where a data proof has gone off and one would expect there to be a new timetable issued allowing another date for productions for the next proof, that isn't always what happens, or it's sometimes necessary to vary the timetable specifically. However, I have been encouraging people to give me any questions that they would like to put to any of the speakers today on the chat function. I don't have any questions here at the moment, but please, if you have anything you want to ask, everybody is still on the call, so any of our speakers today can answer your questions. In the meantime, I'll encourage you to remember, if you would, the Compass Chambers charity for this year, which is the Beatson Cancer Centre charity. And although, of course, today's webinar is free of charge, what we have done is we have put a link on the website to allow you to make a donation to the Beatson. And I know that all charities have suffered this year because of the inability to do face-to-face collections. So if you do have the ability to make a donation, please consider the Beatson, which we're trying to support this year. So I do see we've got a couple of questions coming through. Now, Lisa, I think, had initially been making an observation in relation to the conduct of the Parkinson FAI, and she, having spoken to the family for whom she acts, discovered that in fact they did not feel disadvantaged in any way, although they hadn't been keen on proceeding virtually, obviously, before the hearing started. And she's made the observation that I think everybody can perhaps see in the comments, that one of the useful things which was possible to do was for agents and counsel to have a discussion 3 times a day. And that assisted the progress of the hearing. Is that your experience, Gavin, that where it's possible to have that face-to-face involvement, it's beneficial?
I think that's right. And like all these things, when preparation is thorough, it works. And so if people schedule regular opportunities to communicate around the hearings themselves, then it works very well. And I think where families are participants in an inquiry, clearly they are more involved and they are part of the body of people communicating as the inquiry progresses. The position may be slightly different, in my opinion, for interested members of the public who are not participants and are therefore reliant purely on following the proceedings virtually. Where I think sometimes to be able to follow the proceedings but not have the sort of access that they might have to all the evidence because so much of it is condensed to writing, then I think that can raise issues if they do not have ready access to the written documents in which they have an interest. There's a very good point which is made about the Parkinson FAI. Yeah.
And a general question. Sorry, Amber.
I was going to add something. It was something I was going to say anyway, but I think a couple of us have touched on, and it leads on from this in terms of communication when it's WebEx, and just how important it is to think about that beforehand, whether it's setting up a WhatsApp group or making sure that you're keeping an eye on your email, because you can't tug the gown in these sorts of situations, and it can be difficult. So that's just a very short point to make sure there's a line of communication for these hearings. But I'll move on.
Absolutely. And even when you have a contentious telephone hearing, I find it's quite useful to have a WhatsApp chat or even a Zoom call going on mute, so that you can get messages during the appearance. A question from Anna Black in relation to using WebEx in evidential hearings. And she's asking, do the panelists believe that virtual giving of evidence will be used more for reasons of expense, timing, and as Gavin, you've already said, the convenience to experts who are perhaps based all over the country or all over the world?
I think there will be a push for that by those who have an interest in expenses, whether those be participants in proceedings or the Scottish Government or others who fund litigation. So I can readily see that. We are, of course, used to taking evidence via video link in a variety of situations, even before COVID. And I think we ultimately may move away from inquiries conducted wholly virtually in time to move back to something more of the traditional model. But as I indicated, I think it will end up being a hybrid where certainly there will be, perhaps in the course of one inquiry, a number of witnesses giving in-person evidence and perhaps a greater increase of witnesses giving evidence either over the WebEx platform or virtually as we become more familiar with it. And I think we'll end up with a mix of modes for the giving of evidence.
Anybody else got any input on that, on the prospect of more reliance on technology, even once we're back to normal, whatever that's going to be?
Well, it's just, even in our bus crash case, quite a lot of the evidence was given from passengers who were from down south through a solicitor's firm. They gave their evidence via video link, and it all worked fine. And it saved a huge amount of time and effort for them.
And great, we've got another question actually, Robert, that I think you can answer. Anis Mackay is asking, how can you vary the timetable only for your own productions, because the last date for productions in a timetable provides that it's for both parties?
Yeah, just to be clear, what had happened in that case was the original time for lodging witnesses and productions had expired. So it was then incumbent on the parties to seek further time. And I don't see any reason why you couldn't vary the timetable only in relation to one party, because, and in fact, I think that makes sense to do so, because, you know, to justify that to the court, as happened in that case, there's quite a carefully worded motion explaining what the productions were, why they were being lodged late, all the rest of it. And then in response, the defendants just lodge all their reports without any explanation at all. So, and as the judge, Sheriff Holligan, said, no doubt the sheriff would have taken a very different view to the motion had they known what the defenders were planning.
And I've had a case this week where Lord Doherty's done exactly that for a report that's going to be late. Prospectively, it's known it's going to be late. And so he's made a variation to the timetable only in relation to that one report. So I think it's possible, Anis, but perhaps a situation where you have to look very carefully at the wording of your motion and make sure that the court doesn't go beyond it, if that's possible. And a question for you, Kate, from Michelle Adam. Do you think that SWIFT is now the correct approach for accommodation costs, I think in the Scottish context, and observing that it appears to be generally good news for pursuers? What do you think about that?
Well, is it the correct approach? Well, it's the approach which should be, if you follow the Court of Appeal judgment, that is the approach. And I think if the matter is raised in the Scottish Court, that will be the approach taken. In terms of judging whether it's correct or not, I suppose a defender might say, well, that's outrageous. And yes, it's good news for the pursuer. But going back to fundamental principles, whatever side of the bench you're on, if the object of compensation or an award of damages is to put the pursuer back in the position that they would have been but for the accident, then it's a method of trying to achieve that. I think it's Personally, I think it's a better method than the method in Roberts for the reasons I hope I explained, the problems with Roberts. But equally, it has its difficulties because there's still uncertainty depending on discount rates changing, etc. So yes, it is good news for the pursuers, but perhaps it's good news for defenders because there's more certainty. And curiously, in the case of JR against Sheffield Teaching Hospitals, the defendants ultimately settled the accommodation claim. Although the law was with them, they settled it out of court pretty much at the value that had been sought at first instance.
And I suppose for one of the options put before the court in argument was for simply the award of the capital cost of the new accommodation.
Yes.
And that would have been the worst outcome
Yes.
for defenders. So this does appear to be an effort at recognising fairness on both sides to some extent.
Yes, absolutely.
And a question for Robert from Ian Scott. There's been comment following the Lochs and Glens case that in certain cases a judge might benefit from expert assistance, similar to that which is available to the chair in tribunals. Do the panel have any thoughts about that?
Well, I should say that there was quite extensive expert evidence led by both sides in the case, and the judge had the opportunity and he took the opportunity to ask the experts a number of questions. So I'm not sure that particular case is necessarily a great example of the need for that. It's a road traffic accident case where the courts have generally said there should be limited expert evidence in the first place. But as a general point, I think it's a really interesting one. I think it would be a good idea. I can't see it happening simply because of the cost point of view.
Yes, particularly in a case where there's already expert evidence on both sides. Was that relating to the physics of it, Robert? How much force would be required to generate the loss of control?
Yeah. So we had some reconstruction expert. We also had engineering expert about the forces necessary and how far that would cause a vehicle to deviate, at what speed, and at what point it would tip over, and all the rest of it. So there was a lot of technical evidence in it, but ultimately, that's not what the case turned on.
No. Great point. Thanks, Ian. And I think that's all.
I've just noticed Kay has reminded me, and I meant to plug this earlier, and because I was running out of time, forgot. But there is a very good article on our website on Swift by Grant Markey and Adam Black. And Robert has also written an article which is either in Green's Reparation Bulletin now or will soon be in that. So there's more information out there.
That's great, and that'll all be linked through our website, will it, Robert, when the Green's Reparation article comes out?
Oh, I'm not sure I'm allowed to do that. I'll find out. But it's in Green's Reparation Bulletin anyway. Always worth reading.
It's in Green's anyway. And as you said, we've got the article on the website. Now, I think that is all the questions. We're just after 2:00 now, so it just remains for me to thank all of our panellists again for their time today and the effort that's gone into their very interesting and useful talks. I feel I've actually been brought up to date, having been working in isolation for goodness knows how many months now. So thanks very much, everybody. And thanks to all of the participants for tuning in today for the webinar. We're very grateful for your time as well.
Thank you all. Here's hoping next year is better than this one.
Yes.
Very good.
Moral.